right, everybody, it's time for your daily dose of the Fani update. Judge Scott McAfee issued his ruling in the defendants Michael Roman, Donald Trump al. motion to disqualify Fani Willis and Nathan Wade from that case and to dismiss the charges of the RICO indictment. I had predicted the judge was going to disqualify Fani Willis and Nathan Wade, but not dismiss the indictment, that he would appoint a district attorney from another county who would have to take over this file, this steaming pile of a dump of a judicial file, and decide whether or not to prosecute, to pursue those charges. Judge Scott McAfee issued his ruling today. It's not that I was part wrong or part right in my prediction. It's that the ruling doesn't make sense within the four corners of the ruling itself. Judge Scott McAfee, as he's drafting this, you can literally hear the devil on his shoulder and the angel on his shoulder arguing in real time. You got to do it, Judge. Don't do it, Judge. You can see this happening in real time. The judgment does not make sense on its own. The judge contradicts himself throughout in terms of coming to findings of fact that would wholly warrant a disqualification, only to then say, but I'm going to walk you through the decision and highlight the sections that I think are the most relevant. It's a steaming pile of judicial dog poop of a judgment in a steaming pile of judicial dog poop of an indictment. And people who said that Scott McAfee was corrupted, that he had donated to Fani Willis's campaign before, that he had worked under or with Fani Willis and he wasn't going to disqualify her, they're feeling damn vindicated right now. This judgment, which attempts to split the judicial baby, ends up killing the judicial baby that is justice. Congratulations, Scott McAfee. You killed baby justice. Starting from the beginning, which is always a good place to start, order on defendant's motion to dismiss and disqualify the Fulton County District Attorney. Among other allegations of disqualifying conduct, the defendants contend that the district attorney obtained a personal stake in the prosecution of this case by financially benefiting from her romantic relationship with Special Assistant District Attorney, SADA, Nathan Wade, whom she personally hired to lead the state's prosecution team. We're not going to start from the beginning of this and explain the basis of the motion to disqualify. I presume everyone watching this now has at the very least watched some of my summary videos, if not having watched the trial in real time with me. Suffice to say, it's a bit of a straw man characterization of the basis of the motion to disqualify. It's not just that Fani Willis had a personal stake, benefited financially from her relationship with Nathan Wade in the context of the prosecution of this file. She did. It's that her conduct was outright egregious, unethical. She hid facts from people that she knew she had to hide the facts from because of the appearance of impropriety. She lied under oath. She conducted herself in a manner unbecoming of a district attorney. But alas, this is how Judge Scott McAfee oversimplifies the actual conflict of interest to being one of a financial interest in the conviction of this case. Let's carry on. After receiving 2.5 days of testimony, during which the defendants were provided an opportunity to subpoena and introduce whatever relevant and material evidence they could muster, the court finds that the defendants failed to meet their burden of proving that the district attorney acquired an actual conflict of interest, in this case through her personal relationship and recurring travels with the lead prosecutor. The other alleged grounds for disqualification, including forensic misconduct, are also denied. Recall that Adam Abate, in his stellar, world-class of a performance of closing arguments, argued that Fani Willis needed to have an actual conflict of interest, a pecuniary conflict of interest, in the outcome of a conviction on the prosecution, and that's what it should be limited to. Either way, the judge came to the conclusion that is untenable by his own judgment that there was no actual conflict of interest. And then he also dismisses the basis of the disqualification under forensic misconduct, being that Fani Willis outside of court made statements that were prejudicial to the defendants. And again, it's not that I mind being wrong in my prediction. It's that the reasons for which the judge came to this conclusion were contradicted by his own drafting of this order. You'll read towards the end that Fani Willis's conduct in the statements that she made before the church were legally improper. And I'm quoting the judge, and yet somehow the forensic misconduct did not warrant disqualification. In total, defendants point to an aggregate documented benefit of at most approximately $12,000 to $15,000 in the district attorney's favor. The district attorney and Wade testified that these expenditures were not meant as gifts and not designed to benefit the district attorney. Both testified that the district attorney regularly reimbursed Wade in cash. Yeah, these expenditures were not intended to be gifts, but they would have been had they not been reimbursed in cash. They weren't intended to financially benefit Fani Willis, but they did. But they were reimbursed in cash, except there's no evidence of that anywhere in the file. And just wait until you hear what the judge has to say about the alleged reimbursement in cash of all these gifts and expenses that Nathan Wade bestowed onto Fani Willis in the context of the prosecution of Donald Trump, in which he was hired by Fani Willis and paid in the amount of roughly $700,000 over the course of 2 years, give or take, and over the course of which she was taken on 5 cruises within 7 months with Nathan Wade. Nothing to see here, but let's just see what the judge has to say about the reimbursement in cash allegations. Such a reimbursement practice may be unusual and the lack of any documentary corroboration understandably concerning. Yet the testimony withstood direct contradiction, was corroborated by other evidence, for example, her payment of airfare for the two on the 2022 Miami trip, and was not so incredible as to be inherently unbelievable. Somehow the defense could not disprove the allegation that Fani Willis repaid Nathan Wade in cash with no traceability. Somehow they could not disprove that. It is so wild. And the explanation is not, quote, inherently unbelievable. I'm not sure what the burden of proof is here. I suspect it's preponderance of the evidence. And now the judge is saying this explanation, which can never be disproven because it's based on the absence of evidence, is not inherently unbelievable, and therefore, although improper, although bizarre, although it raises serious concerns, I'm going to allow it. But wait, there's more. In the context of the absence of an actual conflict of interest, according to Scott McAfee, despite his actual findings of fact, this is what the judge has to say. Similarly, the court further finds that the defendants have failed to demonstrate that the district attorney's conduct has impacted or influenced the case to the defendant's detriment. Oh, really, Judge Scott McAfee? I will remind everyone of the terms Scott McAfee uses at the end of this decision. Legally improper, the statements that Fani Willis made in front of the church, but apparently none of her conduct was to the detriment of the defendants, despite it being legally improper because it referenced or referred to one of the defendants. None of the conduct was to the detriment of the defendants except what Fani Wade said was, quote, legally improper, and apparently there are no consequences to legally improper conduct by the district attorney. And speaking of the otherwise stellar conduct by Fani Willis in the context of this relationship over the course of years, and specifically her conduct in court, this is what Judge Scott McAfee says while effectively retaining Fani Willis's defense to this motion to disqualify. Without sufficient evidence that the district attorney acquired a personal stake in the prosecution or that her financial arrangements had any impact on the case, the defendant's claim of an actual conflict of interest must be denied. This finding is by no means an indication that the court condones this tremendous lapse in judgment or the unprofessional manner of the district attorney's testimony during the evidentiary hearing. Rather, it is the undersigned's opinion that Georgia law does not permit the finding of an actual conflict for simply making bad choices, even repeatedly, and it is the trial court's duty to confine itself to the relevant issues in applicable law properly brought before it. There's no actual conflict of interest despite repeated mistakes, totally unprofessional conduct, out-of-court statements that are legally improper. There's no actual conflict of interest. Move along and let's go to the appearance of conflict of interest, which there is, that somehow Fani Willis manages to escape the consequences of, and it is Nathan Wade who will fall on the sword, as we will get to at the end of this vlog. Appearance of impropriety. Finding insufficient evidence of an actual conflict of interest does not end the inquiry. Our appellate courts have endorsed the application of a, quote, appearance of impropriety, end quote, standard to state prosecutors, even without any explicit finding of an actual conflict. So despite all of those tens of thousands of dollars of gifts and travel, Fani Willis alleging she repaid it in cash with no evidence whatsoever to corroborate that, and is very concerning, highly irregular, yada, yada, yada. Despite her unprofessional conduct on the stand, her repeated mistakes, there's no actual conflict of interest, but there is an appearance of conflict of interest. While formally undefined in Georgia precedent, an appearance of impropriety is generally considered, quote, conduct or status that would lead a reasonable person to think that the actor is behaving or will be inclined to behave inappropriately or wrongfully. I consider myself to be a reasonably reasonable person. I don't just have a fear of that occurring in the future. I have evidence of it having occurred repeatedly, systematically in the past, up to the present date, right in front of your eyes, Scott McAfee. Oh my goodness. Some people were suggesting that Scott McAfee got the call from Fani Willis. Maybe that Scott McAfee got the call from Joe Biden or the actual President Obama or the actual president-to-be VP Kamala Harris. Some people are hypothesizing that Scott McAfee got the call. I don't go to intentions, I only go to outcome. This was the wrong decision, period. Most importantly, were the case allowed to proceed unchanged, the prima facie concerns raised by the defendants would persist. As the district attorney testified, her relationship with Wade has only, quote, cemented, end quote, after these motions and, quote, is stronger than ever, end quote. Wade's patently unpersuasive explanation for the inaccurate interrogatories he submitted in his pending divorce indicates a willingness on his part to wrongly conceal his relationship with the district attorney. As this case moves forward, reasonable members of the public could easily be left to wonder whether the financial exchanges have continued, resulting in some form of benefit to the district attorney, or even whether the romantic relationship has resumed. Oh my goodness, Scott, no. Wade's propensity to lie under oath, to conceal assets from his wife, it's not just an issue as relates to him concealing his relationship with Fani Willis. It's an issue of him being a liar, a perjurer, arguably a tax evader. These are the prosecutors prosecuting the president who are themselves guilty of perjury, clear as the day is long, concealing assets from their wife in the context of a divorce, both of them fabricating lies that they submitted to you that you just gobble down. Oh yeah, you paid them back in cash? Okay, that's good. You get off free. But how does Judge Scott McAfee disregard the testimony of Terrence Bradley, Nathan Wade's former friend, business partner, and lawyer? How do they disregard Ms. Yurdy's testimony, the former good friend of Fani Willis? There's ways. Bradley's impeachment by text message did not establish the basis for which he claimed such sweeping knowledge of Wade's personal affairs. In addition, while the testimony of Robin Yurdy raised doubts about the state's assertions, it ultimately lacked context and detail. Even after considering the proffered cell phone testimony from defendant Trump, along with the entirety of the other evidence, neither side was able to conclusively establish by a preponderance of the evidence when the relationship evolved into a romantic one. Only if you are absolutely blind to the facts, Scott McAfee, Terrence Bradley had no basis to know what he said he knew to Ashley Merchant in the text messages. Oh, other than, years of a business, friendship, and lawyer relationship with Nathan Wade. Oh, Robin Yurdy lacked context and detail. No, she didn't. She said it started in November-ish 2019 when they were judges at the municipal court, that it was an open secret of sorts, that she witnessed overt acts confirming this romantic relationship. These facts are not difficult to discern, let alone on the basis of the preponderance of the evidence. These facts are clear and plain as day. Come here, what do you want? You want to say hi? Come say hi. Oh, here's Pudgy. She wants to say hi. What do you think? You think he got it wrong? He got it wrong, Scott. Come on. Get out of here. Scott, you got it wrong. These facts are as clear as day. Everyone saw it in real time, and now everyone gets to know that you are not a judge that can be relied on to apply the law to the facts as you saw them yourself. But at the end of the day, the judge does come to the entirely reasonable conclusion that all things considered, there is the appearance of a conflict, and the solution that he proposes in the judgment, which has already been implemented as at the time of shooting this vlog, is as follows. There has not been a showing that the defendant's due process rights have been violated or that the issues involve prejudice to the defendants in any way. I just want to bookmark that again. Wait until we get to what the judge writes on the forensic misconduct. The defendant's rights, due process, have not been prejudiced in any way by the, quote, legally improper statements made by DA Fani Willis to the church, but whatever. Here's what the judge proposes by way of solution. Nor is disqualification of a constitutional officer necessary when a less drastic and sufficiently remedial option is available. The court therefore concludes that the prosecution of this case cannot proceed until the state selects one of two options. The district attorney may choose to step aside, along with the whole of her office, and refer the prosecution to the prosecuting attorney's counsel for reassignment. Alternatively, Sada Wade can withdraw, allowing the district attorney, the defendants, and the public to move forward without his presence or remuneration, distracting from and potentially compromising the merits of this case. Spoiler alert, Scott McAfee, too darn late. Faith in this case, faith in this DA is long gone, and it's not because they concealed their relationship. It's because they lied, concealed assets, perjured themselves, arguably tampered with witnesses when Nathan Wade is alleged to have sat down with Terrence Bradley 5 weeks ago and inflicted a case of legal amnesia. You had another, I think it was an assistant district attorney, someone with a high position up, ready to testify that she heard Fani Willis on the phone with Terrence Bradley telling him they're coming after us, don't talk to them. Arguably, but not so arguably, witness tampering. Faith in this DA, in this prosecution is done. But alas, maybe you've opened the door to either a successful appeal or maybe a successful ethics complaint, because the facts that you have detailed in this decision, sure as sugar, would justify, warrant ethics complaints, ethics sanctions. But just wait, because we haven't gotten to how we get around the forensic misconduct and what the judge says as relates to Fani Willis's conduct. That certainly didn't prejudice the rights, the due process interests of the defendants. Sure, right? No? And just to refresh anybody's memory who might not recall what we're talking about here, Fani Willis, after the motion to disqualify had been filed, but before she had formally responded to it judicially, gets up in front of a church, pretends that she's only being gone after because she hired a black man, whereas the other two attorneys that she hired were white and no one was going after them. Why is that? Oh, it's because Nathan Wade Wade is black. That's what she was telling to the church while basically denying that she was having an illicit relationship with Nathan Wade, without disclosing to the church that the reason anyone was going after Nathan Wade was because of his illicit relationship with Fani Willis. She gets up in front of a church at the pulpit of God to lie to all of the congregants, to hide facts that were material to the motion in the first place, to pretend that it's all racially based and it has nothing to do with the overt improper acts that we saw in court. This is what the judge has to say to get around all of that. The court finds, after considering the statement as a whole, under all the circumstances surrounding its issuance, that the district attorney's speech did include defendant Roman and his counsel within its ambit, whether intentional or not. So the speech where Fani Willis literally lied before a congregation of churchgoers included defendant Michael Roman. But remember, he said earlier in his decision, none of the defendant's due process rights have been violated by Fani Willis's conduct. But you could literally see the ping-pong intellectual game that this judge is playing. The devil on his shoulder and the angel on the shoulder fighting in real time. It's like, oh, it did involve Michael Roman. However, the speech did not specifically mention any defendant by name. But it was still legally improper. When Fani Willis got up in front of that church and made statements to the effect that they were only going after her and Wade because of racism, it did include Michael Roman, but it didn't mention him by name, but it was really legally improper. But she's going to get off anyhow because, according to the judge, despite all of this, nothing that Fani Willis did compromised the due process rights of the defendants. Okay, that makes sense according to the judgment itself. Hashtag sarcasm. Conclusion. Whether this case ends in convictions, acquittals, or something in between, the result should be one that instills confidence in the process. A reasonable observer unburdened by partisan blinders should believe the law was impartially applied and those accused of crimes had a fair opportunity to present their defenses, and that any verdict was based on our criminal justice system's best efforts at ascertaining the truth. Any distractions that detract from these goals, if remedied under the law, should be proportionately addressed. After consideration of the record established on these motions, the court finds the allegations and evidence legally insufficient to support a finding of an actual conflict of interest. However, the appearance of impropriety remains and must be handled as previously outlined before prosecution can proceed. The defendant's motions are therefore granted in part and denied in part. So beautiful, so thoughtful, almost judicial poetry, if you will. It's a load of crap. Everybody knows it. Nobody has faith in this prosecution. It's just that one side is going to be happy that it gets to go on with Fani Willis, at least for the time being, and the other side, and anybody who watched this trial knows that Judge McAfee, he blew it. But the prosecution cannot continue until Fani Willis makes a hard decision. Is she going to withdraw from the file and her office, or is she going to cut ties with Nathan Wade? Well, Nathan Wade has fallen on the sword, already issued a statement. He is resigning. Wade and Campbell firm via hand delivery. Dear District Attorney Willis, the furtherance of the rule of law and democracy is and has always been the North Star of our combined efforts in the prosecution of those who are alleged to have attempted to overthrow the results of Georgia's 2020 presidential election. Our team is dedicated to ensuring that a Fulton County jury in a Fulton County courtroom renders a true and just verdict in this case. As directed by the order today in State of Georgia versus Donald John Trump et al., I hereby offer my resignation, effective immediately, as special prosecutor for the Fulton County District Attorney's Office. Although the court found that, quote, the defendants failed to meet their burden of proving that the district attorney acquired an actual conflict of interest, end quote, I am offering my resignation in the interest of democracy, in dedication to the American public, and to move this case forward as quickly as possible. I am proud of the work our team has accomplished in investigating, indicting, and litigating this case, seeking justice for the people of Georgia and the United States, and being part of the effort to ensure that the rule of law and democracy are preserved has been the honor of a lifetime. I am sure that the case and the team will be in good hands moving forward, and justice will be served. You, the team on this case, and the entire office have my prayers for your safety and your success in the pursuit of justice. Respectfully, Nathan J. Wade, Esquire. Who here watching this vlog, after having seen Nathan Wade testify, thinks that he actually drafted that statement? I can guarantee you one thing, he didn't. The only question is whether or not it was the Biden communications team or the Fani Willis communications team. One thing is certain, Nathan Wade did not have one hand in drafting his resignation letter, but that's it. That's the outcome. It's not justice, it's injustice. I was wrong in my prediction, but like I always said when I was a practicing attorney, you cannot guarantee results ever. Any attorney who guarantees results is lying. You can't guarantee results. You can only guarantee a process. We went through this. We saw the evidence. I made a prediction based on that evidence, and my goodness, even the evidence as detailed in that judgment warranted disqualification. I don't know if this is 4D chess and Judge Scott McAfee is punting this to the Court of Appeal. Now the Court of Appeal could say, yeah, Judge Scott McAfee, we agree with your findings of fact, and we disagree with your finding of law, so we're going to overturn your decision in part and yeet Fani Willis. Recall that I predicted that in the Colorado decision that kicked Trump off the ballot, that the initial judge came to findings of fact that Trump participated in insurrection, but a finding of law that Article 14, Section 3 did not apply to the president. And I said, why would the judge have come to that finding of fact, despite that finding of law, if it wasn't to set it up for the Court of Appeal to say, all right, we agree with your finding of fact, we disagree with your finding of law that Article 14 does in fact apply to the president, so we overturn your decision, which they did, only to have their decision overturned 9-0 by the Supreme Court of the United States of America. So it's possible Scott McAfee is setting up some sort of reversal by the Court of Appeal, or he just lacked the courage to make the right decision, or he's playing politics with his upcoming election. One thing is for certain, by the judgment itself, the conclusions of law of Scott McAfee do not follow from the facts that he identified. All right, and that is it. I hear dinner is almost ready, and I hear a dog is whining. So if you like what I do, you know what to do. Like, share, subscribe, hit the notification bell, drop a comment in the comment section below. Viva Frei on Rumble, the Viva Frei on Twitter, vivabarneslaw.locals.com. On Locals, we will be talking about this Sunday night with Robert Barnes during our law extravaganza. So join us then, Sunday, 6 o'clock. But more important than anything, exercise, eat healthy, get outside, talk to people in real life, and now you know your vlog. Peace out, peeps.